Hello, everyone. This is Sean here from the Smith Law Firm. I wanted to jump on here really quick to talk about a potential new Fourth Amendment case that could be going before the Supreme Court in the near term. As you know, or those of you who follow our channel, we've been highlighting some Fourth Amendment cases recently, and this new one could be a follow-up to the it could be a follow-up to the Lang versus California case that was just recently decided. This case is entitled Sorenson versus Massachusetts, and it's a kind of unique Fourth Amendment question dealing with one's right to be secure in one's home. The issue is whether or not the police can make a warrantless arrest in front of one's home if they don't live in a detached home, they live in an apartment. Why is that an issue? Well, first, if you live in a detached home, the courts have interpreted the immediate area in front of your home to be part of your home. They call it the curtilage. It could be your front porch, your garage, your driveway. All that is considered part of your home and therefore would require police to obtain a warrant before they make an arrest. You are afforded the same amount of privacy, Fourth Amendment privacy rights, as you would if you were inside your home. Now, in the Sorenson case, it becomes a little bit complex because in this case, Mr. Sorenson was a suspect for an assault and battery. I believe it was a stabbing or something to that effect. And the police got a tip that Mr. Sorenson may have been the perpetrator, although the alleged victim indicated that in the photo lineup that it wasn't him. But nonetheless, they got a tip that it was Mr. Sorenson. They got a tip that he lived in this apartment on the third floor of this apartment building. So they go to visit him, knock on the door. His wife comes out, and ultimately Mr. Sorenson comes out, and they ask him to step outside of his apartment, and they arrest him right then and there without a warrant. I don't know why they didn't get a warrant, but if they didn't have enough evidence for probable cause, that may be the reason. I don't know. Well, in any event, at trial, Mr. Sorenson, he challenged his arrest, alleging that it was a violation of the Fourth Amendment, unreasonable searches and seizures. And basically they said, look, it was a warrantless arrest outside of his home. So therefore, it should be thrown out, any subsequent evidence as a result. The trial court denied that request. He ultimately appealed it to the Massachusetts appellate courts. They denied it as well. And they ultimately said that he didn't preserve the issue for review. And what all that means is, in order for an appellate court to take up an issue, the trial court or the trial court, the lawyer for the person at trial has to preserve the issue, meaning they have to raise the issue in order to provide an opportunity for the appellate courts to review it, to see if the judge made the correct decision. Well, his lawyer at trial did allege a violation of a Fourth Amendment. However, the lawyer didn't say that the warrantless arrest was because it was made outside of his home, or what we call the curtilage area of his home, which is the immediate area surrounding his home. All he said was some general language saying it was a warrantless arrest. So the appellate court denied his appeal. He ultimately had to file what we call a post-conviction relief application. And what that is it's a civil lawsuit alleging some type of constitutional violation. I believe in this case, Mr. Sorenson alleged that his trial lawyer was ineffective because he didn't mention that the warrantless the warrantless arrest was not done, or he didn't do it in the curtilage of his home. He didn't use the word curtilage. He didn't make the specific argument that it was a warrantless arrest in front of his apartment building, and therefore his apartment building is part of the curtilage. I think it's widely accepted that you have to have a warrant if you're going to arrest someone in their home. What's less accepted is whether or not, in terms of an apartment building, that immediate area outside apartment building is considered curtilage or part of the home. It's well settled law that if you live in a detached home or a single family home, that your porch, maybe your front lawn, maybe your garage, that's all considered curtilage of your home and therefore would be afforded full Fourth Amendment protection. But if you live in an apartment building, the issue is less clear. Now, keep in mind, a couple courts have found that right outside of one's apartment building is considered the curtilage of your home and therefore would warrant Fourth Amendment protection. I believe the Illinois Supreme Court has found that. I believe the Texas Court of Criminal Appeals has found that as well. And then some other state and federal courts have found that the area immediately outside of your apartment is, you do have some type of privacy interest in that area, or you have a reasonable expectation of privacy that would require the police to get a warrant if they're going to make arrests in that area. So some courts are split on this issue, and that's the very reason that Sorenson and his lawyers are petitioning the U.S. Supreme Court to take up this issue to kind of settle this law. It'll be interesting to see if the Supreme Court takes this case. They just took up a Fourth Amendment case in California, as I mentioned at the outset of the video, whereby they found that a warrantless search or detainment of a gentleman in his garage was unconstitutional based on a exigency exception to the warrant requirement. That was a misdemeanor case. So I think the Supreme Court may be really looking to take some of these Fourth Amendment cases up for review. We'll be following it to see, one, if they take it up for review, and if they do, the oral arguments and ultimately the decision in this case. If you have any questions regarding this case or have any comments, please leave them below. Thank you.